Hi folks, my name is Sergey Lemberg. I run the consumer law firm of Lemberg & Associates and the website stopcollector.com through the law firm. Here are the 5 things you need to know about Fair Debt Collection Act and banks. The first thing is, as a rule, banks are not covered by the Fair Debt Collection Practices Act. Now, there may be separate laws in different states that cover original creditors such as banks, but the Fair Debt Collection Act, as a rule, does not cover banks. Now, there may be laws in various states that cover original creditors, but the Fair Debt Collection Practices Act does not cover banks. The second thing is, it's not always true. For instance, if a bank is collecting a debt that they bought from somebody when it was in default, that collection of that account would be covered by the FDCPA. The third thing is, banks are original creditors. That means they are not third-party debt collectors. Don't confuse them with third-party debt collectors. Don't confuse them with debt buyers. They're not the same thing. The fourth thing is, if a bank is making it appear like they are a debt collector, or if they get in cahoots with the debt collector to hide the true identity of the person who is collecting, they may be subject to the FDCPA. The fifth thing for you to remember is banks are still subject to the TCPA, the Telephone Consumer Protection Practices Act. So that means they cannot robocall people without their consent. They may not dial automatically telephone numbers for which they do not have express consent to call. So with these things in mind, if you feel like a bank is violating your rights, collecting unfairly from you, you may want to pick up the phone and give us a call. We may be able to help you, or at least point you in the right direction.